Good morning. Welcome to another edition of Legal Access. Today we're going to be talking about personal injury. That envelops a lot of stuff. Car accidents, slip and fall accidents, if you've been hurt on somebody else's premises, even if you've been hurt at work. Any of those topics are perfect for you to call in today and get your questions answered. We've got a great panel here today to answer all those questions on personal injury here today. From the McGuire Law Firm, first of all, Ian McGuire.
Good to see you, Dave.
Also from McGuire Law Firm, Mike Smith.
Good morning, Dave.
And from the O'Neill Law Firm, we got Rick O'Neill.
Good afternoon, everybody.
Yeah, Dave, as you said, we got a great panel here today. Besides myself, Mike has done civil work, but on the defense side for well over 30 years, and we were lucky enough to have him make the move to our firm about a year ago, and it's been fantastic. But he offers such a unique insight for us because he's been on the other side for so long. So that's been fantastic. And of course, Rick has been on the show many times, does a fantastic job, but he's not only does civil work like we do, but he does criminal defense work as well, and he has a unique background because he was in law enforcement. So if you have any questions today, personal injury is a pretty wide gamut of things that you can call and ask about, but also if you have any questions regarding in the criminal realm, don't hesitate to give us a call at 843-848-8080 because Rick could help answer those as well. 843-848-8080 is our number, right, Dave?
Absolutely. Before I forget, I do want to let you know that a couple of things. First of all, if you have any personal injury questions, do not hesitate to pick up the phone and call an attorney because you get free consultations from just about everybody that I can think of as far as personal injury cases are concerned. And also, if you want to know more, you can always go to the McGuire Law Firm or go to the McGuire Law Firm website, which is McGuireLawFirm.com. There's a free book out there for you. It's called Common Mistakes Made by Accident Victims in South Carolina. It's free. You can pick it up at the offices at 1600 North Oak Street in Myrtle Beach, or again, go online to McGuireLawFirm.com and download your own copy. So just some freebies for you here that you want to get. All right, as far as stuff is concerned, now, as far as slip and fall accidents go, we might be getting some rain here over the next couple of days, and there might be some people. Is a defense that well, you should have been looking where you were going, or you should have known that floor was slick. Is that a defense that insurance companies can use?
Well, I will tell you,
Yes.
Dave, that was the number one defense. I've tried many cases and asked jurors after trials, what was the biggest factor in you returning the verdict that you did? And more often than not, it was they should have been watching where they were walking. And the problem with that is that so many stores and other places of business, they bring your eyes up with advertisements and placards and sale cards and things of that nature. So you're looking at all the stuff around you versus looking necessarily at what's in front of you. And it's a trap that people fall into all the time. But yes, that is one of the number one defenses, is you should have watched where you were walking.
And I don't know how many times I've been in a trial and the defense attorney's like, saying to the jury, well, what did your mama tell you when you were little? He said, watch where you're going and watch where you walk. Well, you're not walking and with your eyes down at your feet, looking at your feet the whole time, or when you're crossing the street or stuff. But that's what, the argument usually is, and a lot of times it's a successful argument. But as Mike pointed out, and it's so true, is, we're trained to span, the area really above your feet and what's in front of you, and then there's all these things that are designed to catch your eye's attention. So if a company is aware of a foreseeable risk that people are going to be walking, or there's elderly people, whatever it is, that are being walking on the premises, they have a duty to keep it reasonably safe. And these cases always come down, Rick, right to reasonableness. And what is the definition of reasonable can be different for a lot of people. So that's where most cases, when they end up in a trial, a lot of times that's what it is what is reasonable, right?
And I think it's a reasonable expectation as well, that you're not always looking at your feet. It's not something that everybody does every day. You've got a general idea that the walkways are supposed to be kept safe. But another defense that we hear raised a lot is notice. On those slip and fall premises cases, is did the owner have notice that whatever the harm was on the floor, for example, was there? the infamous grapes on the floor cases in grocery stores. How much time elapsed from the time that grape was on the floor until it was brought to the attention of the store, or unfortunately, when somebody stepped on it and slipped and fell. So notice is a big issue as well.
Yeah, and did they know or should they have known? But Rick and we've talked about in the past how sometimes the better cases as far as proof for a plaintiff is when the defendant created a dangerous condition, right? And that'll happen.
Yeah, for example, shelving in a store. The store put it there. They're maintaining it. They're stocking it on a daily basis. They created it, and they have notice if there's sharp pieces of metal protruding from the shelving. Are you to cut a customer's leg?
Yeah, or they mop the floor and they put the sign in one area instead of the other, and somebody, if they're walking this way, they can see the sign, but they're coming from the other direction, the sign's not visible. So those are things that where they've created a dangerous condition, but usually got to show one of three things: either they knew of a dangerous condition, they should have known a dangerous condition, or they in fact created a dangerous condition.
Now, if somebody's been injured either in a car accident or maybe a slip and fall or trip and fall, and before they've had a chance to hire an attorney, they get a call from the insurance company, from the other party, and they say, "Hey, we'd like to get a recorded statement from you." What is your advice to them as far as what they should do at that point?
Yeah, I mean, it's a rule. Workers' comp cases will allow it for investigation purposes only, but we generally have a rule that we don't do recorded statements because they just don't serve the injured individual well. If they want to get information, they can call and not record it and just ask questions. Right. But they're going to be allowed a deposition later. So then what they'll be doing is taking two transcripts and finding these minor discrepancies and using them to show somebody's not telling the truth and stuff. So I don't know about you, Rick, but I generally just don't allow it.
It's not really fair because they're not going to let us take a recorded statement of the store manager or the clerk or the custodial staff.
Yeah.
Right.
But they want to, have free reign at our clients. It's really not fair for them to be able to take multiple statements from our clients. I mean, sometimes there's a reason to do it, but generally, we say we can give you the information. What information do you want?
Right.
We are being cooperative, but.
And a lot of times the way the adjuster asks the questions, they'll ask a leading question, for example, and the person will walk into that trap of answering the leading question without being given an opportunity to fully explain themselves.
Right.
So you've got to be careful when you do those statements.
Yeah.
Tell you what, we're going to run to a break here real quick. If you have any questions about personal injury, whether it's a car accident, maybe a slip and fall, trip and fall accident, or if you've been hurt on the job, give us a call right after this break. We'll answer your questions and get you all the answers you need. Personal injury, our topic here today on Legal Access, brought to you by the McGuire Law Firm. Welcome back. It is Legal Access. Today our topic is personal injury. If you have any questions about automobile accidents, maybe slip and fall, trip and fall accidents, or if you've been hurt on the job, give us a call. The number's on your screen, 843-848-8080. We'll get you on the air and we'll answer those questions for you live right here on the TV. Now, obviously in automobile accidents and other personal injury accidents, the person who is injured does have the option to represent themselves against the other party and the other insurance company. If they do that, why is that a mistake? Why should they hire an attorney to help them out?
Boss man?
Well, there are times where people come in our office and they have a mild injury and they're fine, but they have, they've had small inconveniences or small injuries, and we'll give them maybe some direction, and they can handle it themselves and settle it with the insurance company. But what happens in those cases, and very, very similar to if you hire a lawyer that's not ever going to go to court and the insurance company knows that, the insurance company is going to tell you the value of your case or the value of your loss. So, you know, if you've been injured and you have significant injury that has some permanency, or it's going to cause you an alteration of your lifestyle, you know, it's worth sitting down with an attorney. The insurance company has their attorneys to represent them, and you really do want to level that playing field. And the only real artillery that we have is to be able to say, that's not fair, we're going to court, we'll have a jury of our peers decide the value of the case. And if an insurance company knows that your lawyer is capable of doing that and will do that, then the value of your case is going to get to hopefully to an amount that's fair and equitable, that puts you in a position where your harms and losses are valued properly. So that's my feelings on
Yeah,
that.
one of the things that I noticed, Dave, before I switched to the plaintiff side was I began seeing more and more offers from insurance carriers that were less than the medical bills, for example. And I know some lawyers, Ian included, don't like to necessarily pin a case value to the amount of medical treatment that you have. But I see offers sometimes that come in and say, well, we'll pay this ER bill and give you $1,000, for example.
Right.
Well, you may have a $25,000 worth of subsequent treatment, and if you grab that quick offer from the insurance company, you know, it's a devastating result for you.
Right.
So, you know, be very cautious about that. And the attorneys that we know will do that initial consultation for you for free. They'll give you that advice to lead you along the way. Generally speaking, the first visit is free, and typically it's a contingency type arrangement that you're not collecting a fee unless you collect for them. So there's really no harm in reaching out to an attorney. In fact, you can save your case tremendously by doing that, because the insurance carrier's business is to save as much money as they can. You know, they're not out to help you as an injured person. They're out to protect their bottom line. So get a lawyer and have that evaluation done.
Yeah. Rick?
Yeah, I mean, so many times we'll have someone come to us with an offer from an insurance company, and we get involved, and whether it's weeks, months, or maybe even, you know, a year or two later, the final settlement amount is way more than the insurance company was offering the unrepresentative claimant in the very first. So, I mean, generally the studies show that if you get represented by an attorney, your recovery, even after deducting the attorney's fees, is going to be higher than if you handle the case on your own.
And I'll reiterate what Ian said from the insurance carrier's perspective. One of the things that they do recognize and understand is who will take a case to trial. That's an important factor in the overall evaluation process, because if the carrier knows that the plaintiff's counsel is not going to go into the courtroom, their tendency to offer a higher amount of settlement is less, much less, because they know that typically that particular lawyer will take the best offer and then fold the tent, so to speak, and go home. Whereas if you will be willing to try a case, and if you are willing to try a case, and you're telling the insurance company, we can't take this amount of money, we've got this plethora of information from past jury verdicts, past jury studies, the multitude of cases we've mediated, this is the value of the claim, not what you're claiming it is right now. So having that experience is a tremendous asset to the plaintiff.
What if somebody calls up the office and says, hey, I was at a bar or I was at a party the other day and somebody came in and just started a big fight and I got injured in this way or the other. Is there any kind of personal injury case there, or is that just a plain criminal case?
It can be a personal injury case. A lot of these bars hire security, and they're supposed to keep an eye out for events like that may escalate. There are certain laws regarding the amount of alcohol that's to be served and who's to be served and when not to serve. All kinds of training programs that these bartenders are supposed to go through. If the bar, for example, overserves somebody, there's some potential liability there. So, you know, you need to look at each case on a case-by-case basis, but it doesn't necessarily mean that you don't have a case just because there was a fight in a bar.
Right.
Yeah, we've had a number of cases with wrongful death cases over the years where somebody was killed by a third party who it was a criminal act, but there should have been an expectation to some degree of safety on the premises, and there just wasn't. And then, you know, there's experts on both sides that are evaluating the area where it happened, and as Mike said, it's a case-by-case basis. But certainly, if you had a family member that went through that unfortunate either injury or, God forbid, death, you know, it's definitely makes sense to sit down and talk to an attorney and find out what your rights are, because there's a lot of times when these things could have been prevented and should have been prevented.
Right.
You know, so.
And also, I mean, if somebody stretches the definition of personal injury a little bit and said that they've been slandered either by whoever or whatever's going on, and they say that's injured my reputation, is that any kind of a case, or is that just, I don't know?
Yeah, that is, it falls under the civil cases called torts. You can bring a case like that. There's a bunch of legal hurdles you have to have as far as your evidence and proof. And, you know, if A says to B something in private that's defamatory and it's just between themselves, it hasn't been spoken to third parties. So you also have to prove that it was, this was said to the community and that your reputation has been harmed and so forth. It's complicated. I mean, those cases do go to court sometimes, but you have to pick and choose if it's the right case, if you've got all the standard proof that you need.
Yep.
Now, Mike, you mentioned a little bit earlier as far as like getting payouts and as far as future meds are concerned. Now, making sure that you've taken care of as far as future operations and things like that are important, but how is that figured? I mean, if you don't know that you might need a back surgery in 25 years or another 15 years, and how much that's going to cost in the next decade.
But typically the insurance companies do not want to pay or offer in settlement an amount that will cover future medical care. So we have tools that you know, the doctor will look at a particular patient, and either in their records or through their deposition testimony, they'll say, well, this particular patient is more likely than not going to need future medical treatment, and this is reasonable treatment for them to use or to undertake. A perfect example of that is, you know, a lot of people have these back problems and they go through this myriad of treatment, from epidural steroid injections, medial branch nerve blocks, and then they do radio frequency ablation. The problem is that's not a cure, it is a treatment, but that particular patient is going to need that treatment every 6 months to 2 years out. So we have medical experts that do life care plans and future cost projections that will actually take what the doctor says, take the recommended treatment, and put a dollar and cent value on it based on the damages model in the area.
All right. Today we're going to run to a break here again real quick. When we get back, we'll have just under 10 minutes. If you have any calls about personal injury, today's the day to get those questions answered. Call us. The phone number is on your screen, 848-8080. Don't be shy and don't be late. Just, again, you got a little under 10 minutes to get your questions in. Want to get you on the air and talk to you here today on Legal Access, brought to you by the McGuire Law Firm. Welcome back. It's the final segment, last few minutes of our show here today as we're talking about personal injury. If you have any questions about personal injury, automobile accidents, slip and falls, trip and falls, or if you've been hurt at work, give us a call. The number's on your screen. Got a few minutes left to answer those questions. On the panel to answer those questions for you, Ian McGuire and Mike Smith, both from the McGuire Law Firm, and Rick O'Neill from the O'Neill Law Firm. Remember also, if you have any questions, a free book is available for you called Common Mistakes Made by Accident Victims in South Carolina. It's available at the McGuire Law Firm office, which is at 1600 North Oak Street in Myrtle Beach, right in the corner of 16th and Oak Street. Stop on by, get your free copy, or go online to McGuireLawFirm.com and you can download your own copy there as well. So give us a call and find out more about it. Okay, medical malpractice, that is obviously part of being injured, or personal injury is concerned, but it's a practice that a lot of personal injury law firms don't undertake. Why not?
Well, for instance, in our case, we have a large practice dealing with people injured in car wrecks, and the doctors that are treating those patients are all in the community, and so it's just from a conflict standpoint, it's really not something that we do. I also, my parents are long gone, but my father was a doctor, my mother was a nurse, so I understand being a physician and being a nurse, you're caring for people, but it's definitely not an exact science, and a lot of times you do everything right and you don't get good results, and I think there's an understanding of that. Now, there are some cases that we have taken over the years because we felt that we felt so strongly about the case, and there's exceptions to everything, but most people, if I would suggest, if they have a medical malpractice, they go to somebody who just concentrates in medical malpractice, and that's their sole area of practice. It's a very unique in ways. In a lot of ways, it's very similar than any other civil case, but there are unique things about them. There's breach of a standard of care. You have to have an extra report before you even get going on the case.
That's
saying
an expensive endeavor.
That breach, yeah, that's another point, great point, Mike. They're very expensive cases to take to trial because you need experts that can get extremely expensive. There's also at times caps on the amount that can be recovered in certain cases. So they're not as straightforward, I would say, as fall cases or car cases. I don't know if you all have anything to add to that.
Yeah, I mean, medical mistakes happen hundreds of times a day according to the studies. So number one, is there any damages? If there's no damages, you don't really have a viable case. And then if there are damages, it's really got to be more catastrophic because the cost to bring one of these cases could be 100, 200, 300,000 easily to litigate those cases. So the injury's got to be a large enough and long-lasting injury or a death case to really make it feasible for an attorney to prosecute that case for you.
Yeah, I years ago I had a friend of mine who was he was a doctor and an attorney, and I would send him cases, and it's something like 1 or 2 out of 100 that they look at, and most if I'm sending them, I think, oh, there's there might be something, and that's how strict they are as for what they take and what they don't take as far as medical malpractice. But I still would urge anybody that if they're having issues to go talk to somebody, because it doesn't cost anything to talk to somebody.
Absolutely. Got to wrap things up here right now. Appreciate you watching today as we've been talking about personal injury. Again, as Ian just said, make sure and call if you have any questions. Call a personal injury attorney because consultations are free, so it doesn't cost you anything to get an idea of whether you should move forward with what's happened to you, whether it's been slip and fall, trip and fall, maybe an automobile accident. Call and find out a little bit more. Remember also to stop by McGuire Law Firm office to get your copy of your free book as far as common mistakes made by accident victims in South Carolina, or go online to McGuireLawFirm.com. For Ian McGuire, Mike Smith, and Rick O'Neill, I'm Dave Priest. HOA is going to be our topic next week, so tune in for the fireworks. That'll be next Thursday at 11:30. We'll see you here, right here on Legal Access.
You may wish to consult a lawyer to obtain case-specific legal advice. Information regarding lawyers can be located online or by contacting the South Carolina Bar Lawyer Referral Service, toll-free at 1-800-868-2284. If you are currently represented by an attorney, you should direct all legal questions to your attorney. The nature of any legal issue may depend on a multitude